Welcome to the asset portion of the Divorce 101 course. Here's where you're going to learn about how we classify assets, how we value them, and how we divide them in a New York State divorce. When we talk about dividing assets in a New York divorce, people often think of community property, and they wonder, are we a community property state? And if you read anything about Hollywood divorces, that's a term you'll often hear. Fortunately, in New York, we're not a community property state. There's only 9, I believe, currently that are. We're an equitable distribution state. Equitable distribution, that's how we divide up assets. 3-step process. We need to categorize the asset to figure out whether it's marital or separate. We need to value it, and then we need to distribute it equitably, fairly. When we talk about equitable distribution, people often wonder, well, what does that mean, fair? And fair, if you're going through a divorce, you and your spouse may have very different feelings, understandably, as to what a fair distribution looks like. Fortunately or not, depending on your view of things, cheating really doesn't play into it. If somebody had an affair, fortunately, unfortunately, that's not something that a court is going to put or should put much weight when they decide how they divvy up the assets. And when I say should, legally, I'm not passing judgment one way or another. There are times in recent years we've seen a little bit more movement with judges willing to listen to fault, and to, if there's egregious fault is a standard we always had that a court could consider in dividing up assets unequally. We don't see it often. However, we're beginning to see the legislator a few years ago added in abuse. And so it is something that when we're dividing up assets, that there are arguments that we can make in favor of an unequal distribution when appropriate. The way we inventory assets for a divorce in New York State, there's actually a court document, a court form that in any litigated divorce is required to be completed. It's known as a statement of net worth. And in that document, we list all of the parties' assets, we list their liabilities, we list their expenses. So it's a really important asset. It's a sworn statement, so it's critical that it's done correctly. It's something that we spend a lot of time with our clients, making sure that we don't miss anything, that we've covered everything, and that as part of the discovery process, often we have clients come in and one side may not know the full extent of their assets. And so that's really where discovery comes into play, and where there's a lot of work for the lawyers to do to make sure that we're covering everything. So when we complete that statement of net worth, when we're compiling the inventory of the assets, it's everything. So it's everything from real estate, your marital residence, if you have a second home, if you have investment properties, businesses, accounts, investments that you may have, whether the investment's cryptocurrency, stock accounts, mutual funds, artwork, when you have things of significant value, jewelry. It really covers everything. Anything that you own that has value, generally in excess of $500, it is required to be listed on the statement of net worth, and it's something that we're going to make sure is there because that is a sworn statement. That is the intent of that is to be a complete inventory of all of your assets. Once we've inventoried the assets, we need to determine, and part of the inventory is determining whether that's marital property or separate property. Because the marital property we're going to value, and then we're going to distribute it equitably. Again, typically in New York, most marital assets are going to be divided 50-50, but there are certain assets, typically the businesses, that are not divided equally. And then there may be arguments to be made as to why a 50-50 distribution is not equitable, is not fair. In mediation, the asset division can be very similar, but in mediation, the parties have a lot more control of the outcome. And in mediation, the parties are also able to be a lot more creative with the help of a skilled mediator in figuring out what works best for both of them. So what we find often in a litigated divorce, when there's not a mediator, often lawyers will just fall back on dividing things equally, dividing things in half, maybe allowing one person to stay in the house. Whereas in mediation, we can get so much more creative, and there's so many more opportunities to really sculpt a settlement that works best for everybody, to maximize those assets across the board. When parties litigate, when they go to court, when it's up to a judge to decide how the assets are divided, a judge is going to be less creative than we might be able to be in settlement or in mediation, for example, or collaborative, if that's how the parties had chosen to approach their divorce. With a judge, they're much more likely to order most assets divided equally, perhaps some assets sold off so that we know the actual value and that we can divide them up. A judge will certainly work hard and try hard to do what's equitable, but of course they have significant caseloads and they only have so much time to hear each party's arguments. When a case is going to be litigated, when it's going to be argued before a judge, it's really important that your attorney have a really good understanding of what the assets are, what your goals are, and what are the best arguments to be made. Because when we go in before a judge, that's where we really need to be aggressive. We need to be very rational and clear as to what we're looking to accomplish and to why. So we need to tell the judge why is our proposed resolution, why is that the most equitable way to resolve things? There are times when we're dividing assets that we can actually create more than what might otherwise appear to be there. One of the ways we do that, one of the most powerful ways, is looking into the tax considerations. So there are times where the parties will end up in very different tax brackets. And so there are things that we can do as we're dividing up assets. We need to consider those things so we can maximize what the parties have to put them both in the strongest place possible.